Mr. Paramjeet Singh Dhaliwal, and Honorable Justice J.R. Midha sir. On behalf of the School of Law, Galgotias University, we feel extremely privileged to have with us such revered guests and to have them present here to guide, to teach and to judge the final round of our Srimati SHAKUNTALA Devi first National Moot Court Competition 2024. It is a matter of great honor, ma'am and sir. Thank you so much. We will now begin with
Your Honours, the counsel shall be taking 22 minutes of the respective court's time, and my learned co-counsel shall be taking 20 minutes respectively. We respectfully reserve 4 minutes for the rebuttals. Your Honours, if Your Honours are well versed with the facts of the case, the counsel seeks permission to proceed ahead.
Yes.
Much obliged, Your Honours. Your Honours, the counsel now seeks permission to proceed ahead with the statement of jurisdiction. Much obliged, Your Honours. Your Honours, the petitioner, that is Sajjai, has approached the Honourable High Court of Uttar Pradesh under Article 226 of the Constitution of India, Your Honours, under the writ of mandamus. The counsel seeks permission to proceed ahead with the contentions. Much obliged, Your Honours. Your Honours, the counsel shall be dealing with the first and second contention. The counsel shall be dealing with the first contention in a threefold manner, Your Honours. Firstly, we shall seek to establish as to why the section and the regulations passed therein under the Uttar Pradesh Police Act are unconstitutional on the basis of them being vague and arbitrary in nature. Secondly, Your Honours, the counsel shall seek to establish as to why the test of proportionality has not been passed in the pertinent matter. And lastly, Your Honours, the counsel shall then seek to establish as to how these regulations and sections have resulted in the violation of the right to privacy of the petitioner in the pertinent matter, Your Honours. Your Honours, at the very outset, the counsel would like to state that privacy and dignity of a human individual has always been held to be an integral part of the experience of being a human being, Your Honours. Your Honours, against the backdrop of this, the counsel would like to draw the attention of the Honourable Bench to page 2 of the factual matrix, Your Honours. Your Honours, if Your Honours are with me, much obliged. Your Honours, the very last paragraph, Your Honours, the second last line, the said provision impart the state government to notify regulations for the purposes of crime control and for furthering public interest, Your Honours. Your Honours, subsequently the next page states the regulations, Your Honours. Your Honours, Regulation 200 states, an inspector not below the rank of a constable can open up history sheets of an individual from digital and non-digital means if he has reason to believe that the individual concerned is suspected to be involved in any cognizable offences or has prior involvement in such an offence or has the potential to become a habitual offender, Your Honours. Your Honours, herein the counsel would like to draw a comparison to the case of Shreya Singhal versus Union of India, Your Honours. Your Honours, therein the Honourable Supreme Court of India struck down section 66A of the IT Act of 2000, Your Honors, on the basis of the terms being used therein, vague, Your Honors. Your Honors, therein the terms being used were annoyance, aggressiveness, criminal intimidation, and none of these terms were defined in the pertinent act, Your Honors. Therefore, Your Honors, Regulation 200, Your Honors, if you are to see in the same lens, Your Honors, reason to believe has not been defined. Furthermore, Your Honors, it states an inspector not below the rank of a constable, Your Honors. Your Honors, there are 8 ranks above the rank of a constable among police personnel, Your Honors. Therefore, the pertinent regulation is very wide in its power and reach, Your Honors, and is open to misuse and abuse by police personnel given to a lack of procedural safeguards, Your Honors. If Your Honors have no questions, then I also like permission to proceed. Much obliged, Your Honors. Your Honors, the Council would also like to draw the attention of the Honourable Bench with the case of State of Madhya Pradesh and another versus Baldev Prasad, Your Honors. Your Honors, herein, the word Gunda was defined, Your Honors. However, Your Honors, the Honourable Bench in that case held that it did not serve any purpose, as any citizen can be held to be a Gunda under the definition given in that act, Your Honors. Your Honors, in the pertinent regulation, the effect is the same, Your Honors. Your Honors, if a police person has mere reason to believe, Your Honors, every single citizen can come under this regulation, Your Honors, and the history sheet can be opened without any justification, Your Honors. Therefore, Your Honors, the Council humbly submits before the Honourable Court that the said section of the Act and the regulations passed therein are unconstitutional on the basis of them being arbitrary and vague, Your Honors. Your Honors, the Council seeks permission to proceed ahead. Much obliged, Your Honors. Your Honors, secondly, the Council now shall seek to establish as to why the said regulations and the section fail the test of reasonable classification and also fail the test of proportionality, Your Honors. Your Honors, the test of proportionality was laid down in the case of K.S. Puttaswamy versus Union of India, Your Honors. Your Honors, wherein the Honourable Supreme Court of India held that there must be a rational nexus between the purpose of introducing a particular section, Your Honors, and the object that it seeks to serve, Your Honors. Your Honors, in the pertinent matter, there is no rationality behind drafting these regulations, Your Honors, as a wide discretionary power has been given to police personnel, Your Honors. Your Honors, the Council would again like to highlight that no safeguards exist in the pertinent regulation, Your Honors. Every single term is free to be open to the interpretation of the police personnel, Your Honors. Secondly, Your Honors, in the case of Anwar Ali Sarkar versus State of West Bengal, Your Honors, it was held that intelligible criteria for making a distinction between groups of individuals could be made, Your Honors. Your Honors, the Council herein would also state the case of Peoples of Union Civil Liberties versus Union of India, Your Honors, wherein a 3-pronged test was laid down by the Honourable Supreme Court. Your Honors, therein the Honourable Supreme Court of India held that bulk surveillance could not be classified as targeted surveillance, Your Honors. Your Honors, in the pertinent matter, the issue is the same, Your Honors. Your Honors, given the wide connotation of the term reason to believe, Your Honors, every single citizen is under the purview of this regulation, Your Honors. Therefore, Your Honors, this regulation carries out bulk surveillance, Your Honors, which is prohibited, Your Honors. Secondly, Your Honors, therein the court also held that there has to be the existence of safeguards within the regulation, Your Honors, and they have to be narrowly tailored. Your Honors, in the pertinent matter, that is not the case, Your Honors. Your Honors, the regulation and the section has not been narrowly tailored, Your Honors, and thus infringes the right to privacy of individuals, Your Honors. Your Honors, the Council seeks permission to proceed with the third fold argument, Your Honors.
Before you proceed,
Indeed,
we have a question.
Indeed, Your Honors.
You are challenging the regulation itself,
Indeed, Your Honors, and the section in which it was passed, Your Honors.
but the power that has been given
Indeed.
to open up history sheets
Indeed, Your Honors.
is conditional upon reason to believe
Indeed, Your Honors.
and reason to suspect that the person is involved in a cognizable offense or has prior involvement in such offenses or has the potential to become a habitual offender.
Indeed, Your Honors.
So can you really question the regulation, or are you going to question the action which is being taken in abuse of the regulation?
Indeed, Your Honors. Your Honors, the Council understands and recognizes Your Honors' concerns. However, Your Honors, in the pertinent matter, if Your Honors are with me,
Yes.
Your Honor, in the pertinent matter, the factual matrix makes it abundantly clear that in the wake of these regulations, Your Honor, Mr. Bajirao started surveilling this property of Sachibai and Radhabai, Your Honor. Therefore, Your Honor, the Council would humbly contend before the Honourable Bench that the said regulation in itself is so wide, Your Honor, no procedural safeguards have been listed, Your Honor. Therefore, it is unconstitutional, Your Honor, as it gives arbitrary power in the hands of police personnel who are not below the rank of a constable, Your Honor. Your Honor, there are 8 ranks above the rank of a constable among police personnel, Your Honor. Therefore, a wide net has been laid out by the state, Your Honor, wherein bulk surveys can be carried out under the guise of these regulations, Your Honor. Therefore, Your Honor, the council would humbly contend the fact that the said term in itself, reason to believe, is wide in power, Your Honor, and is very vague and can be misused by police personnel, as was done in the pertinent matter.
See, I have a question to you. Object of this provision is to be aware of the antecedents, and it uses the word reason to believe.
Indeed.
So we can further clarify that the person has to make a note in the police diary that what is the basis of the reason to believe, and see the larger objective to be achieved. Let's assume a person applies for a government job and he was involved in a cognizable offense. It doesn't disclose there, so we can immediately check from the record whether this person has got a record or not. Avoid a criminal to be entering police force. People enter the large number of cases where the people apply for a government job, for army, for police job, and they had a criminal background. They don't disclose. There is a question column: are you involved in any criminal case? They say no. So we can just open and see. What is the? How do we otherwise control? Please tell me.
Indeed.
So we can clarify that the reason to believe the police officer has to record there. That this is that what is the basis on which the reason to believe is there.
Indeed, Your Honor.
So
Your Honor,
why should a larger objective be overlooked?
Your Honor, the Council understands and recognizes the Honourable Bench's concerns. However, Your Honor, in the case of E.P. Royappa versus State of Tamil Nadu, it was held that public policy cannot be manipulated to carry out arbitrary actions, Your Honor. Your Honor, in the pertinent matter, Your Honor, even though the object might be to safeguard the citizens, the inhabitants of the state of Uttar Pradesh, Your Honor, what these regulations did instead were intrude upon the fundamental rights of the citizens, Your Honor, in the pertinent matter.
I'll give you a more clear example. Let's assume a person applies for a job in the army.
Indeed.
Right? And now the person who has to do inquiry, he goes there, and in the neighborhood is asked from everybody, and everybody says this person was involved in a criminal case, whereas that person has not disclosed. So now there is a reason to believe. So he will come back in the office and note down that everybody in the locality is saying he was involved in a rape case. So we'll check and you will get the history sheet, and you will not give him a government job. How much danger it will be to the society and to the country? See the larger objective, no? Why should such a regulation not be upheld?
Indeed. Your Honor.
And number 2, have you addressed on the question number 2 also? Or you are only on question number 1?
Your Honor, issue number 1. The Council is deliberating on issue number 1, Your Honor.
Or
Your Honor, the Council would humbly beg to differ in the pertinent matter, Your Honor. Your Honor, the said regulation, as stated earlier, Your Honor, fails the test of bulk surveillance, Your Honor. Your Honor, herein...
Not bulk surveillance. If a person has a reason to believe he is involved in a criminal case, only then. And he has to write down in his diary, what is the basis? Now the basis can be that everybody in the locality is saying he is involved in a criminal case, don't give him a government job. So he writes down that everybody is saying so, he'll write the name of the person also. And then he will open the record. So what is wrong with it? Why should we protect a criminal and the record of a person to be hidden from the society?
Your Honor, herein the Council would humbly contend that the term reason to believe is very subjective and can differ from police personnel to personnel, Your Honor. Therefore, Your Honor, what might be reasonable to me, Your Honor, might not be reasonable to the next person. Therefore, Your Honor, a wide power has been given to every single police personnel, wherein if they feel fit, if they, in their heads, Your Honor, have reason to believe that XYZ can become a potential offender in the future, Your Honor, they can intrude upon the right to privacy and violate their act.
That power with the police is always there. Kindly see a murder has happened and police has a reason to believe this person is involved. So he can immediately take action. So that power of the police is otherwise also there at every level.
The reason to believe has to be a real reason.
Indeed, Your Honor.
So, what weight with the police may be questionable, but can the regulation, the act itself be struck down?
Your Honours, the Council understands and recognizes the Honours' concerns. Your Honours, in the case of Kharak Singh versus the state of UP, Your Honours, it was held by the Honourable Court itself that if the police could do what they did to that petitioner in the pertinent matter, Your Honours, they could also do the same to an honest and law-abiding citizen. Herein, Your Honour, the regulation does not state about the criminal history of a person, Your Honours. It also talks about the potential of a person to become a habitual offender, Your Honours. Therefore, if a police personnel feels fit in his head, if he has reason to believe that XYZ can become a potential offender in the future, Your Honours, despite them having a clean record, Your Honours, surveillance can still be carried out, Your Honours, right to privacy can still be violated. Therefore, Your Honours, the Council will humbly submit before the Honourable Bench that because of the lack of procedural safeguards in the regulation itself, Your Honours, the said regulations be declared unconstitutional, Your Honours. If that satisfies Your Honours' questions.
Would the court declare the provision itself unconstitutional?
Indeed, Your Honours.
Or will the court give such an interpretation to the Constitution which makes it reasonable and non-arbitrary?
Indeed. Your Honours, the Council...
With permission, I have a question also. Hello.
Yes.
When legislation is enacted, two things are important. One is public interest, another is the legislative intention, which has been violated as per your argument in this case. Because the enactment has been passed keeping in view the fact that there is a crime everywhere. To check that this legislation has been specifically passed, you have not said anything how this is against the public interest or how it is affecting the common man.
Indeed.
You have to answer that.
Indeed, Your Honours. Your Honours, the Council would reiterate that given such a wide-reaching power in those regulations, Your Honours, every single individual, as the Council stated earlier, can come within the purview of these regulations, Your Honours. Furthermore, Your Honours, Section 46, if Your Honours would kindly turn to page 2 of this action matrix, Your Honours. Your Honours, if Your Honours are with me, much obliged, Your Honours. Your Honours, the second last line states, the said provision impart the state government to notify regulations for the purposes of crime control and for furthering public interest, Your Honours. Your Honours, with the limited information which has been given in this action matrix, Your Honours, the Council has safely ascertained that the terms herein used are also vague and arbitrary, Your Honours. Your Honours, therefore, in the name of public policy, the state can still pass regulations which infringe upon the rights of the citizen. I sense a question.
Explain to us how they are arbitrary.
Indeed, Your Honours, indeed. Your Honours, in the case of Shreya Singhal versus Union of India, almost a similar question was posed before the Honourable Bench, Your Honours, wherein they looked at these terms, Your Honours, of Section 66A, such as annoyance, criminal intimidation, public nuisance, aggressiveness. Therefore, Your Honours, therein the Honourable Bench held that because these terms have not been defined anywhere, Your Honours, because these terms had a subjective meaning, Your Honours, because they differentiated from person to person, Your Honours, therefore the said section was liable to be struck down on the basis of it being arbitrary, Your Honours.
What was the provision which was applied?
Because of the penal consequences.
Indeed, Your Honours.
Here it's procedural.
What was the provision in Shreya Singhal which was quashed? Just read that provision.
Your Honours, apologies, Your Honours, Council does not have the exact provision. However, it was...
When you rely on it, was the, if we go by your reasoning, then the law of preventive detention has to be squashed. That has been tested so many times. A person commits an offence, and the department has reason to believe that he will commit again.
Indeed.
They can, on the ground of preventive detention, said, put him in jail.
Indeed.
Without there being any offence.
Indeed, Your Honours.
Only reason to believe that this person may commit offence again. So, such a wide power given. So, if we go by this logic, then the entire prevention detention that has been challenged so many times has been upheld. Today, the law is in very much in force. A person has committed offence and police feels he will commit it, so they put him in jail for 6 months.
Indeed.
So, you put him in jail, no case, no FIR, no criminal case, wide power given, reason to believe.
Indeed, Your Honours.
So, some basis has to be there for the
Can you tell us which provisions of the Constitution have been violated? Any fundamental right?
Apologies, Your Honours. If Your Honours could kindly repeat that question.
Do you know the fundamental rights in the Constitution?
Indeed, Your Honours. Your Honours,
Under what provision, under what article you are arguing?
Your Honours,
You are taking this court of which article?
Your Honours, the Council will rely upon Maneka Gandhi versus Union of India, wherein the golden triangle between.
That is a citation.
Indeed, Your Honor.
I am asking of the article, relevant article.
Your Honor, is 21 and 14, Your Honor. Article 21 and 14, Your Honor. The council is relying upon those.
What is the relevancy of 21?
Your Honor, right to privacy has been enshrined in Article 21, as was explicitly stated in the case of K.S. Swamy versus Union of India, Your Honor. Your Honor, herein, the council would like to draw the attention of the Honorable Bench to page 3 of the factual
First,
matrix.
tell me what was the principle laid down in Menka Gandhi case?
Indeed.
On which you are relying. What is the principle?
Indeed. Your Honor, therein the Honorable Supreme Court held that fundamental rights can be connected, Your Honor. Your Honor, they partly overruled the case of A.K. Gopalan versus State of Madras, wherein the Honorable Supreme Court refused to connect Article 19 with 21, Your Honor. Therefore, Your Honor,
What is the law laid down in Menka Gandhi principle? Total law was changed. Article 14. What is that principle of law?
Indeed, Your Honor. Your Honor, therein they held that a person's right to personal liberty, Your Honor, can be restrained on a procedure established by law, Your Honor. Your Honor, however, the established procedure must be just, fair and reasonable, Your Honor.
Very good. Yes.
Your Honor, the council would like to proceed. Much obliged, Your Honor. Your Honor, page 3 of the factual matrix makes it abundantly clear that constant surveillance was carried out against such under the wake of these regulations, Your Honor. Your Honor, Bajirao used to enter her house at odd hours in the night, Your Honor. It is also alleged that he forced her to install an application on her phone that would make her location known at every single point in time. Furthermore, Your Honor, if Your Honor would please have the Honorable Bench's attention to the last line of the second paragraph, Your Honor. Lastly, he bribed the vendor outside her house to keep a check on her activities. Your Honor, the peculiar use of the word bribed, Your Honor, in the reference to a vendor, Your Honor, raises and reeks of the personal vendetta being carried out by Mr. Bajirao, Your Honor. Your Honor, page 3 of the fact sheet, Your Honor. Your Honor, therefore, the council would humbly contend that because of the wake of these regulations, Your Honor, and the section, Your Honor, Sajibai's right to privacy was violated on numerous occasions in the pertinent matter, Your Honor. Your Honor, if Your Honor is satisfied with the first contention, the council seeks permission to proceed ahead with the second contention. Much obliged, Your Honor. Your Honor, the council shall be dealing with the second contention again in a threefold manner. Firstly, we shall seek to establish as to why the police cannot delegate investigative functions to private parties. Secondly, we shall seek to establish as to why non-core functions of the police can be.
Which is the private party involved here?
Your Honor, the vendor. Your Honor, the vendor was bribed to keep a check on Sajibai's activities, Your Honor. Much obliged, Your Honor. Your Honor, thirdly, the council shall seek to establish as to why the state cannot claim the immunity of carrying out sovereign actions in case there's an infringement of fundamental rights, Your Honor. The council seeks permission to proceed. Much obliged, Your Honor. In the case of Gulab Singh Rana versus, I see it's a question. Indeed, just 2 minutes. Indeed, Your Honor.
Private investigation is not permitted if there is the agreement with police and the particular agency to find out the scientific evidence against
Indeed.
person and other things against that person.
Your Honor, herein the council would humbly contend that would fall under the assistance of the police, Your Honor, and that would not be a delegation of its power, Your Honor. Your Honor, in the Model Police Act of 2006, Your Honor, 2 clause H, Your Honor, lays out what core functions are, Your Honor. Your Honor, therefore, the council would humbly contend before the Honorable Bench that only non-core functions of the police can be delegated, Your Honor. Your Honor, this was something which was discussed in the case of.
Police is not equipped to find out the scientific evidence. They have to make some arrangement and agreement with some forensic agency.
Indeed, Your Honor.
And they are exposed, and we are taking copy of evidence which we are collecting by way of the various power positions and etc. Then that is relevant. Only then they will have to seek the assistance of other experts.
Indeed, Your Honor.
So then they can certainly ask for the investigation through a private person.
Indeed, Your Honor. Your Honor, the council humbly submits to that fact. However, Your Honor, the council is seeking an extension of just a minute, Your Honor. Much obliged, Your Honor. Much obliged, Your Honor. Much obliged. Your Honor, the council herein would beg to differ and state that, Your Honor, when Your Honor, a dead body is given to a forensic lab, Your Honor. Your Honor, the forensic lab does not find the dead body itself, Your Honor. Your Honor, the investigation is carried out by the police, and in furtherance of the same, to ensure a speedy trial, they give it to the private labs, Your Honor. Your Honor, herein it would be an assistance instead of a delegation, Your Honor. Your Honor, the contention is that investigative functions, whether they can be delegated or not. Your Honours, the council humbly contends that investigative functions of the police cannot be delegated as were done in the pertinent matter, Your Honours. As the last line of the third paragraph of the third page, Your Honours, of the fact sheet clearly states that he bribed the vendor to keep a check on her activities, Your Honours. Your Honours, further, the council would like to state a case to wrap up its arguments, Your Honours. The case of Hardam Singh was the state of Punjab. Herein, Your Honours, the Honourable Supreme Court laid out what non-core functions of police could look like, Your Honours. Your Honours, these could be collection of dead bodies, these could be manning reception desks at police stations, and these could also be compilation of case diaries, Your Honours. Your Honours, therein, the Honourable Supreme Court encouraged the police to delegate their non-core functions in order to focus on their core functions, which they only could exclusively perform, Your Honours. Therefore, Your Honours, the Council humbly contends before the Honourable Court that investigative functions of the police cannot be delegated to third parties, Your Honours. If that satisfies Your Honours' questions, the Council would like to call upon its co-counsel to deliberate further. Much obliged. It was a great matter of honour and pride to argue before the Honourable Bench.
That each individual possesses an inalienable right to preserve his or her privacy, and on that very foundation his personality thrives, Your Honours. The right to privacy, Your Honours, is an underpinning of human dignity and is quintessential to the realization of human rights, Your Honours. As far as the pertinent matter is concerned, the right to be forgotten stems from right to privacy, as has been held in paragraph number 88 of the recent judgment of Kaushal Kishore versus State of Uttar Pradesh, Your Honours. The Council would also like to shed some light on the judicial precedent of Google India Private Limited versus Vishakha Industries, wherein adequate heed had been paid on the right to be forgotten, enabling a person to obtain removal of search results which violated his or her privacy interests, Your Honours. It is humbly submitted before the Honourable Bench that the right to be forgotten, or rather the right to be remembered, cannot be denied to the person if the facts and circumstances so commend it. Moreover, Your Honours, in today's reality of certain enhanced and oftentimes cumbersome visibility, the court is vested with inherent powers to mask or redact the names of people who have been acquitted earlier, Your Honours. The strength and sensitivity of a constitutional court would suffice in this regard, Your Honour. This has been time and again reiterated in certain cases. These include Karthik Theodore versus Registrar General Madras High Court also, Your Honour. Moreover, it should also be noted that once the petitioner has been acquitted, her information in the public domain would unequivocally jeopardize her impression in the society, taking a toll on her mental health and her future prospects as well, Your Honour. Moreover, Your Honour, the fulcrum of any society following the rule of law would be to reform a person and not to condemn or castigate her, that too when she has been acquitted by one of the prominent judicial forums of the country, Your Honour. The Council would also like to state that adequate heed must also be paid on the fact that publication of judgments in the online domain and allowing them to remain there forever infringe upon the right of a party based on the right to be forgotten, as has been enshrined in the case of X versus Union of India, Your Honour. It is pertinent to note that an individual should not be treated with respect to his or her previous antecedents, Your Honours. As far as the pertinent matter is concerned, Your Honour, an antecedent is not even formed as the petitioner had been acquitted by the trial court after due consideration of as many as 12 witnesses, 15 exhibits, murder weapons and all the possible documentary evidence also, Your Honours. The Council would also like to state that no woman would want her want that her grey shades of her character should be depicted, and especially in those cases when the woman is the victim, Your Honour. It has been reiterated. Much obliged, Your Honour. Your Honour, by this phrase, grey shades of character, the Council would like to imply and contend that in the pertinent matter, Your Honor. Your Honor, many judicial precedents, the landmark cases being Megha Gandhi versus Union of India and Olga Tellis versus Bombay Municipal Corporation, reiterate that a right to life is not restricted to mere animal existence, Your Honors. As far as the pertinent matter is concerned, the Council, while researching for the pertinent case, has time and again stumbled on various judgments wherein the Honorable Judicial Forum has not been tight-handed in granting the right to be forgotten to a woman, Your Honor. Moreover, there are various judgments like the recent one being the writ petition of a Madras High Court, Your Honor, wherein Justice Anand Venkatesh observed and contended that although the person accused in the earlier cases was charged of Section 470 and Section 376 of IPC, but later on he was duly acquitted by one of the lower forums of the judiciary, Your Honor. The pertinent judge stated that today the world is literally under the grips of social media. Whatever you see, you seem to believe. And you cannot probably go to each and every person explaining him the legal nitty-gritties, especially when the common public is not even aware of what the legal jargon signifies, Your Honor. The mere fact that your name is in the judgment gives the public enough substance and reason to conclude itself that he or she might have done something suspicious, Your Honors. Also, the Council would like to state that in the case of Vasunatham versus High Court of Karnataka, the Karnataka High Court took this into consideration that the name of the petitioner's daughter should be redacted as it is taking a toll on the reputation of the petitioner in the society, Your Honors. Moreover, the Council would again like to reiterate that as far as the fact sheet is concerned, page number 2 of the factual matrix under the trial header, it has Section 228A of IPC, Your Honors. The Council seeks permission to proceed. Much obliged, Your Honor. If the Council would like the Honorable Bench to have a look at page number 2 of the factual matrix under the header trial, the third paragraph, it has been stated that the trial court on September 12, 2022 recorded the statements of 12 witnesses, examined 15 exhibits, which included the murder weapons and other documentary evidence. The court found out that Sachibay's offence could not be proved beyond reasonable doubt and acquitted her, Your Honor. Your Honor, instead of taking a toll on her reputation in the society, Your Honor, page number 2.
Beyond reasonable doubt. There is a difference between honorable acquittal and reasonable doubt.
Your Honor, to answer this question of the Honorable Bench, the Council would like to state the case of Commissioner of Police, New Delhi and another versus Meher Singh, which is a 2013 judgment, wherein the court observed that on honorable acquittal, it was held tantamount to being acquitted beyond reasonable doubt, not on the basis of on the benefit of some doubt, and it stated when the accused is acquitted after full consideration of the prosecution case and the prosecution miserably fails to establish that in the pertinent matter the accused has committed a crime, that would be an honorable acquittal. As in the pertinent matter, the Council was drawing a corollary between this judgment and the factual matrix. Herein, the prosecution had unequivocally failed to establish that Sachibai had committed the murder, even after considering 12 witnesses, 15 exhibits, murder weapons, and the documentary evidence on it.
Quantity is not relevant. Only the quality of witness is relevant. Here only benefit of doubt has been given.
Much obliged, Your Honor. Your Honor, she has been acquitted.
Case of honorable
Much obliged, Your Honor. Since the Council hereby believes that since such a judgment has been passed by one of the prominent lower forums of the judiciary, and that too when she has been acquitted beyond reasonable doubt, so this should be taken into consideration. However, the Council also understands the concern of the bench members. This acquittal should also be honored in the society, Your Honor, and considering this, the right.
You see, you have relied on so many judgments. What is the test laid down by the courts? In which case this right to forgotten should be given? In which case it should not be given? What is the test?
Much obliged, Your Honor.
Every case person who goes to the court claiming right to be forgotten, he is not given relief, right? Some cases the court declines, some cases the court accepts. What is the test laid down in so many cases?
Much obliged, Your Honor. Your Honor, other country. When he came to India, his job prospects got affected. So the court took cognizance of this fact and declared that right to be forgotten should be granted. Moreover, time and again,
The test laid down which cases, what test we should apply,
much obliged.
which cases we should allow right to forgotten, which cases we should not allow. Please tell the test. What is the test? And then we'll apply that test to your case.
Your Honor, moreover, when the person is acquitted and
So
cogent
does
evidence,
every person who is acquitted should be given a right of forgotten? Please tell me.
much obliged, Your Honor.
I'll give you a very simple example. In the Nithari murder case, where a person in Noida committed 19 rapes, then murder of 19 girls and women, then rape with the corpse, then cut the body cooked, and after cooking the body ate the parts and threw the skull in the drain behind it. Right? Well known case. By a judgment of 26th October, the Allahabad High Court has acquitted him. Shall we give him the right of forgotten? Should not it be known to the whole public that this is the person? And there's so much of evidence, it shook the conscience of the entire country when the incident happened. Front page news. It never happened even prior to independence also.
much obliged.
And the person was convicted by the sessions court and given the punishment of being hanged. Now he has been acquitted. Shall we give him right of forgotten?
Indeed not, Your Honor.
Why? What is the test?
Much obliged, Your Honor. Moreover, as far as the precedents which had been prior to this argument stated by the council, the court is considerate when it comes to women and children, Your Honor. Moreover, the section 3 clause 14 of the Juvenile Justice Act also takes into consideration that whenever a child is acquitted, total obliteration of information should be done, Your Honor. So, to test, moreover, no, Your Honor, that's basically to corroborate to the argument of the council, Your Honor. Council seeks permission to move on. The council seeks permission to proceed. Much obliged.
What principle is applied when deciding a civil writ petition under Article 226? You are taking the benefit under Article 226 and asking for the same.
Your Honor, the council seeks humble apologies, but at the moment the council is not aware of the principle involved. Moreover, the council would retort and be back with the principle involved at the end of the rebuttals. With the due permission of the court, the council seeks permission to proceed towards the
Have you
court.
heard the word preponderance of probability?
Indeed, Your Honor.
So what applies to criminal law and what applies to the civil law?
Much obliged, Your Honor. Your Honor, as far as the pertinent matter is concerned, the petitioner was not even a one-time offender, Your Honor. So the petitioner, by approaching the forum of the Honorable High Court, contends that since she was not even a one-time offender, why should she be the one to bear the brunt of somebody else's early sinful practices, Your Honors? So seeking that,
This is not your contention that the person who had filed an FIR was having particular motive against her. What is the specific motive it is mentioned in the fact?
much obliged, Your Honor. Your Honor, the council would like to draw a link of the motives in the forthcoming contention, Your Honor.
He was saying that you should marry me.
Your Honor, as far as right to marry is
So that was the motive on that this is false FIR. Why you have not asked on this on taken this ground for that?
That's what you should have argued.
much obliged, Your
I
Honor.
am putting in your mouth to say something, you will have to say.
Your Honor, with the due permission of the bench, the council would establish the principle of res gestae in the forthcoming argument, which would most probably answer the questions of the honorable bench, Your Honor. The council seeks permission to proceed with the fourth contention. Much obliged, Your Honor. For the ease of understanding, the council would like to divide the contention into two folds. The first dealing with the fact that every individual has a right to marry, and in the pertinent matter, the right to marry shall not stand suspended. And the second fold dealing with the fact that right to marry in the pertinent matter shall override the right of a potential spouse to be protected from sexually transmitted diseases, Your Honors. Coming on to the first.
protection from this unwanted
Indeed, Your Honors.
disease of HIV.
Indeed, Your Honors. The council
Why
to
it is
answer.
parents?
Indeed, Your Honors. The council to answer the question of the bench would like to highlight the cases or the facts of the case of Mr. X versus Hospital Z, Your Honor. Wherein before marriage, the person was found to be contracted with HIV/AIDS, and the doctor, exercising his power in the partner notification of Chapter 7 of Code of Medical Ethics, found it pertinent to disclose it to a to-be spouse, Your Honor. As far as the pertinent matter is concerned, Your Honor, the fact sheet unequivocally states that Bhajirao he was not even sure, he made an allegation that the person with whom she was allegedly committing sexual intercourse is at a high risk of getting transmitted or getting contracted with HIV/AIDS, Your Honors. The council would like the honorable bench to consider page number 3 of the factual matrix, Your Honors, wherein under the header and attempt to flee, it has been mentioned that Bhajirao reached out to Manoj's family, informing her of the sexual encounters inside the jail and that she was at a high risk of sexually transmitted diseases, Your Honors. Your Honors, the Act on HIV/AIDS 2017 only mentions that a authorized or a pertinent medical personnel under the code of confidentiality should keep such information latent and not breach the right of privacy of the person concerned, Your Honor. However, under partner notification, it would disclose it, Your Honor. Your Honor, as far as the pertinent matter is concerned, Bhajirao was not even a medical personnel. He made this disclosure on the basis of his personal capacity. That too was not sure, Your Honor. However, the council would like to humbly submit that once no medical test has been conducted in the pertinent matter, and it's only based on hearsay, Your Honor. Once the medical test is conducted, and if the petitioner is found to be positive, the council would humbly submit that the right to marriage stands suspended, Your Honor. But before that, the council would like to contend that it was merely a hearsay, Your Honor.
Why you are not going for damages and defamation?
Your Honor, the council is about to.
Right to know.
Your Honor, the council was about to cite a case of Bombay High Court wherein the respondent made a false charge of his wife having contracted HIV/AIDS, but when the medical test was conducted subsequent to this allegation, it was found that nothing of this sort was there and it was spurious, Your Honor. And there the claims of defamation were given, Your Honor. Your Honors, the council would also like to draw, if the Your Honors are satisfied, the council would also like to draw a chain of circumstantial evidence suggesting res geste, which states that Bhajirao had an ulterior motive of defaming the petitioner in the pertinent matter, Your Honor. Point number 1, Your Honor, under the head of tribulations, the very next day Bhajirao went to post to Sachibai, also offered to speak to her parents. She was taken aback by what was going on and vehemently refused, Your Honors. Point number 2, which is on page number first itself, Your Honors, this was followed by constantly sexually colored remarks both from Bhajirao and Mr. Ahuja, Your Honors. Point number 3, which is on page number 3, states that Bhajirao started regularly visiting Sachibai's house, including at odd hours in the night, and he allegedly forced her to install M-Spy application, installed a CCTV camera, bribed the vendor. And point number 4, which is under the header and attempt to flee, the same page, Your Honor, wherein he went up to Manoj and his family and made a very surreptitious disclosure that she is alleged to have carried HIV disease with her, Your Honor. This states that whatever instances the council has struck out from the factual matrix should give the honorable bench enough substance and reason to conclude that there was instead a benefit or an ulterior motive on part of the investigation officer itself, Your Honor. Moreover, even if a person is found to be much obliged, Your Honor. Your Honor, if the honorable bench is satisfied with the contention of the council would like to proceed towards the prayer, Your Honor.
Whatever you want to say, we have extended 1 minute.
Much obliged, Your Honor. In the light of the facts of the case, issues raised, arguments advanced and authorities cited, the council on the behalf of the petitioner humbly prays before the honorable court to kindly adjudge and declare that section 46 of the Uttar Pradesh Police Act 1949 and Uttar Pradesh Crime Control Regulations 2023 stand unconstitutional. Point number 2, that police can cannot delegate its investigating functions to private parties and is liable in case of breach of fundamental rights. Point number 3, that Sachibai has a right to be forgotten with respect to erasure of a previous criminal record. And point number 4, that right to marry does exist with respect to Sachibai, and in the pertinent matter, the right to marry will unequivocally override the right of a potential spouse to be protected from sexually transmitted diseases and or pass any such order, decree or judgment that the Honorable Court deems fit in the best interest of justice, equity and good conscience, and for this act of kindness, the Council as in duty bound shall forever pay. With this, the Council would like to wrap up with the entire argument, and it was indeed a matter of great honor arguing before the Honorable Court. Much obliged.
It was indeed a pleasure for us to hear you both tackling the most difficult questions which were coming from the bench. Yes. Yes.
Greetings to the Honorable Bench. The Council highly appreciates the gracious presence of your leadership. However, for the convenience of the proceeding, the Council would like to address the bench collectively as your Lordship. The Council humbly submits the compendium on the behalf of respondents.
Please do not address the bench's options.
Indeed, your Lordship.
You can adopt a more gender neutral form of address.
Indeed, your Lordship, the Council will. I am the Council, along with my co-counsel, on the behalf of respondent in the present matter of Ms. Sachibai versus the state of Andhra Pradesh. For the same, the respondent would deal with the case with the 4 issues, where the first 2 issues would be dealt by me, and my co-counsel would be dealing with the further issues. If your Lordship is well versed with the facts, the Council seeks permission to proceed with the first issue. Moving to the first issue, your Lordship, issue 1 pertains that whether section 46 of the impugned legislation is unconstitutional. It is humbly submitted before this Honorable High Court that the section 46 of the impugned legislation is constitutional and there is no fundamental breach or right. There is no fundamental right breach. Your Lordship, to prove the same, the Council argument will be threefold. Firstly, there is no violation of Article 14 of Ms. Sachibai under the section 46 of the impugned legislation. Secondly, there is no breach of Article 19, Clause 1, Subclause D. Thirdly, there is no breach of Article 21 under the Constitution of India. Moving towards the first contention of your Lordship, that the state action has not led to a breach of Article 14 of the Constitution. I will be proving the same with the twofold argument. Firstly, there is a reasonable classification. Your Lordship, the first critical factor to consider the classification is regarding the legality of any regulation passed is based on 2 factors. As laid down in the case of Anwar Ali Sarkar versus State of West Bengal 1952, the Supreme Court held that the classification is reasonable if it is based on intelligible differentia and as a rational nexus to the objective sought to be achieved. And coming to the first limb, that is intelligible differentia, the classification must be based on reasonable differentiation. Just here also, basis of the classification but based on the people who had the potential to harm people. In the present matter, if your Lordship may turn to page 2 of the moot proposition.
In Anwar Ali Sarkar versus State of West Bengal, what was the issue?
Indeed, your Lordship, the Council will be referring to the same further arguments.
Asking a question.
You referred to a judgment. What was the issue in that judgment?
Thank you for the question, your Lordship. I will be referring for just a 10 seconds.
Just tell us.
So apologies for the same. The council will be dealing it later. If your lordship may turn to page 2 of the moot proposition, paragraph 2, states that the petitioner Sachibai started shouting at Mr. Sunday and pricked his hand with a pen multiple times. Her history, including incidents like breaking our classmate's hand out of distress, suggests a potential risk to the other human beings in the society. Therefore, this justifies her classification under Article 14 as it meets the criteria of reasonable justification. Secondly, there is rational nexus, but there must be a logical reason between the act and the objective that is sought to be achieved. And in the commencement of the regulation of these impugned legislation, section 46 of the impugned legislation, that was to curb the increasing crime, and hence the rational nexus was also present. In the present matter, if your lordship may turn to page 2 of the moot proposition, where it is clearly mentioned that the state provision empowered the state government to notify regulation for the purpose of crime control and furthering public interest. These regulations were passed in the wake of increasing crime in Uttar Pradesh. Moving to the second sub-issue, that is equals must be treated equally and unequals must be treated equally. The first condition is that the statute is following the principle of equals must be treated equally and unequals must be treated equally. The principle is mentioned in DEVI versus PEC, University of Technology, and it means that law is not applicable universally, hence it has to be equal for the equals and different for the equals. In the present case, Ms. Sachibai situation sets her apart from the other people in the society, and the decision to put surveillance on her was justified. Her past actions such as breaking her classmate's hand due to the mental agony indicates a potential risk to the other human beings in the society. Thus, this satisfied the requirement for a reasonable justification in the Article 14. Going towards the second part of the argument, that is section 46 of the impugned legislation does not violate the Article 19 clause 1 subclause D of the Constitution of India. And firstly, the restrictions imposed on Sachibai were reasonable and proportionate to the situation at hand, considering Sachibai's potential risk to the safety. As stated in the Article 19 clause 5, the restriction can be imposed on the ground of interest of general public, and also in the present matter, if your lordship may refer to page 2 of the fact sheet in the last paragraph, if your lordships are with me, where it is clearly mentioned, these said provisions empowered the state government to notify regulations for the purpose of crime control and for furthering public interest. These regulations were passed in the wake of increasing crime in Uttar Pradesh, and also the restriction imposed on her was in the favor of general public interest. As in the case of Kedarnath Singh versus State of Bihar 1962, the Supreme Court held that stating restrictions on one's freedom movement are acceptable when they are required to maintain the public order. And in the light of this, monitoring on Sachibai is considered legal as it is carried out in the way that upholds the public security and deters criminal activity. Coming to the third fold of the argument, that there has not been any breach of Article 21 under the Constitution of India, as the Constitution of India under Article 21, the procedure has to be just, fair and reasonable and not arbitrary in nature. As laid down in the landmark case of Megha Gandhi, the term law and procedure established by law was interpreted to mean that mere formal legislation. It emphasized that law must be fair, reasonable and justice rather than being arbitrary and oppressive. Firstly, regulation under section 46 of the impugned legislation are just as they undergo the public safety and maintain a balanced approach of the safeguarding individual right. They ensure fairness through proportionate measure and are subject to judicial review. Secondly, the act is fair because it ensures everyone's safety while still respecting the individual right. In the layman term, if I could elaborate, it's like having rules on the ground to save everybody, play equally and without getting hurt. Thirdly, as already been proven before, the act is reasonable, hence there is no violation of Article 21 of the Constitution of India. And in the present case, the restriction imposed on her did not violate her right to privacy, as these regulations were passed out in the favor of national security and public interest. As emphasized in the case of Prabhakar Pandurang Sansgiri versus State of Maharashtra 1966, the Supreme Court emphasized that the critical significance of procedural safeguard in maintaining individual freedom during Article 21 of the Constitution was not violated because appropriate procedural safeguard was placed in Sachi's observation. If your Lordship are satisfied with the presented argument, the Council would proceed with the further issue. The Lordship's second issue deals that can a police delegate its investigating function to private parties, and if yes, who bears the liability if the action concerned lead to breach of an individual fundamental right? The Council shall be dealing it with this two folds. Firstly, there has been no delegation of investigating function by Mr. Bhajirao, and secondly, surveilling by the private party is a common practice. Moving to the first fold of the argument, the Council humbly submits before this Honourable Court that keeping a watch by a private party cannot be necessarily with a delegation of investigating function. The private party is not conducting the investigation or making decisions about the same. They are merely providing surveillance or they are providing surveillance footage or information that may be used further as a evidence. Here I would like to clarify, Your Lordship, that investigation focuses on analyzing evidence and solving crimes, whereas the surveillance is more about monitoring and collecting information. According to the section 39 of the CRPC states that normal person can also help the police in the surveillance. And here in the present matter, vendor was just providing the surveillance. And in the light of that, as by the directives of the Pradhan Mantri Smart Policing, under the Delhi police practices, there have been several schemes like Police Mitra schemes in which it has been stated local help, local police and ticketing duties, traffic management, collecting of law and order arrangement. 1,862 police mitras have been co-opted by under this scheme. Hence, it is a very common practice that local people help the police to do the surveillance practice. And also in the case of Gwalior Rayon Silk Manufacturing Cooperative Limited versus the Assistant Commissioner of Sales Tax has discussed the concept of delegation. The delegation is not complete handing over a transfer of power from any one person or body to another person to another. Delegation is defined as entrusting by a person or body of person or of the exercise of power residing in that person or body of person to another person or body of person. And moving towards the second
question. What is the relevancy in the murder case of surveillance? Surveillance, keeping in the facts mentioned in this proposition, what is the relevancy? Because in the case of death of Mr. Ambuja, what is required? How the surveillance is relevant?
Thank you for the question, Your Lordship. But however, in the present matter, the surveillance was not put because of the death of Mr. Ambuja Pant. Rather, it was put because the regulations that were passed in view of the curbing the crime rate in the increasing in the Uttar Pradesh. That is why the surveillance was put on her. If that satisfies your answer, the Council seeks permission to proceed with further. And moving towards the second part of the argument, that is surveillance by the private actor is a common practice. The police delegates surveillance power to private individuals such as conducting inquiries, gathering evidences or making arrests. It involves a deeper involvement in the criminal justice process beyond mere observation or monitoring. As laid down in the case of Malak Singh versus State of Punjab and Haryana, the Apex Court said that as long as the surveillance is for the purpose of preventing crime and is confined in the limits prescribed under a specified provision, a person whose name is included in the surveillance register cannot have a genuine cause for the complainant. Moving to the second contention, that there has been no violation of fundamental right by the vendor, as firstly, the right to privacy is not absolute. Pertaining to the same, the Council humbly submits before this Honourable Court that there has not been any infringement of the fundamental right of the petitioner, as the vendor was only here with mere surveillance and not investigating that what is petitioner doing. And therefore, in the case of Malak Singh versus State of Punjab and Haryana, the surveillance was conducted by authorities to curb criminal activities and not to harass the petitioner. As such, it was deemed necessary to protect public interest and does not infringe upon the fundamental right of the petitioner and guaranteed under Article 14, 19, 1 subclause D and 21 of the Constitution of India. And similarly, here also, this mere surveillance does not violate the Article 19, clause 1 subclause D, Article 14 and Article 21 under the Constitution of India. If your Lordship are satisfied with the presented argument.
Another question, you read the
was conducted by a private vendor, and if it violates the fundamental right, hence the state will not be held liable for the same, because the private vendor is not a part of the state.
Our private have been given some agreement must be there.
Certainly,
You
Your
are
Lordship.
authorizing a person to collect such and such type of evidence by way of surveillance or otherwise taking photographs, watching the movements of person. There must be some contractual agreement when you are authorizing a person. State must be liable for that.
Certainly, Your Lordship, but here in the present matter, Mr. Bhajirao approached the vendor, not the state approached the vendor for the mere surveillance.
Baji Rao is a police officer.
Certainly,
He
Your
is an
Lordship.
investigating officer also.
Certainly,
So
Your Lordship.
why he is not acting on behalf of the state?
But the state is here not vicariously liable for the same. Because the actions that were made by the Bhajirao was out of the course of her employment. It has not been certainly satisfied, stated in the fact sheet that the action of surveillance was in the course of employment, and hence the state is not liable for the same.
Investigation is not a part of the duty as an official of the state. When
Certainly,
he is investigating a case.
certainly, Your Lordship, if you could summarize your question.
And that the question is, state is the principal. All the officials who are working on behalf of the state while in the investigation of a crime or the surveillance with regard to a person, an individual who is a threat to the society, public at large. They are not performing public functions and on behalf of the state.
Certainly not, Your Lordship. Here in the present matter, the action done by Mr. Tejwa Bhajirao was not in the course of his employment, and thereby the state cannot be held liable for the same.
An employee is not liable. Whatever I do, being an employee.
Being an employee, I am in
State, I
the
am investigating, I am appointing person, private person to make surveillance acts.
certainly not, Your Lordship. If I could
What
just
is the basic principle with regard to the vicarious liability? You said vicarious liability, not liability. What is the fundamental principle with regard to vicarious liability?
if I am appointed somewhere, and if I am that in course of the employment, then only I can be held liable. If I am working somewhere for 9 to 5, and if I do something after 5, I cannot, the party which has hired me cannot be held liable for the same. If I do something after 5. Thank you, Your Lordship. Certainly, Your Lordship. Certainly, Your Lordship, he is acting as my agent, but that too was not clearly stated in the fact sheet that the appointment of the vendor was in the course of employment of the Mr. Tejwa Bhajirao. So hence the state cannot be held liable for the same. If Your Lordships are satisfied with the presented argument, I would like to call upon the second co-counsel to speak with further issues. It was a pleasure arguing with you.
Again, greetings to the bench. Your Honor, this is the co-counsel representing the respondent, and the counsel will be dealing with issue 3 and issue 4. The counsel seek permission to commence with the issue. Much obliged, Your Lordship. Your Honor, issue 3 deals with Sachibai's right to be forgotten in terms of permanent erasure of her past criminal records. The issue at hand will be proved on 2 grounds. Firstly, Lordship, the right to be forgotten is not absolute, and it is subjected to certain restrictions. It will be proved the following ground that right to be forgotten is subjected to certain restrictions. The respondent contends that right to be forgotten is indeed part of Article 21 of the Indian Constitution, but that the right to be forgotten is not an absolute right. The request may be denied in certain circumstances, such as when it contradicts the right to free expression and information, or when it is conflicting with public interest, which is justified ground. The case of the history sheets of the habitual offenders. Consequently, Your Honors, where public interest is included or when an association is utilizing information while practicing its authority, it can refuse to delete any information that it considers to be significant for its purpose. Your Honor, in India, the question previously come before the judiciary in the case of Dharam Raj Maharashtra, where the Gujarat High Court did not acknowledge right to be forgotten of the petitioner charged with criminal conspiracy and murders, which was further also supported by divisional bench in Gujarat High Court. Your Honor, it was held that petitioner claim for the judgment being non-reportable and the respondent should be banned from publishing it on the internet because it would jeopardize the petitioner's personal and professional life and did not violate Article 21 of the Constitution, and the petitioner has presented no legal basis to prevent the respondent from publishing the judgment. Your Honor, furthermore, in the case of K.S. Swami versus Union of India, Supreme Court has stated right to be forgotten was subject to certain restrictions, and hence it cannot be used in the present case as well, as there is an involvement of execution of a duty in the name of public interest or public health, as well as the protection of information in the name of public interest, which account as the necessary ground for the reasonable restriction imposed under a right to be forgotten. If Your Honor, we refer to page 2 and last para of the proposition. If Your Lordship's out with me. Your Lordship, it is stated that the said provision empowered the state government to notify the regulation for the purpose of crime control and furthering public interest. Those regulations were passed in the wake of increasing crime in Uttar Pradesh. Your Lordship, Uttar Pradesh Crime Control Regulation, which allowed the opening of history sheets of the accused, was passed to regulate the increasing crime, ensuring public interest and safety of the citizen. Sajibai's right to be forgotten was restricted by these regulations according to the procedure established by the law to control the crime rate of Uttar Pradesh. Your Honor, secondly, it is a sovereign power of the state to make laws. As stated by John Austin, law is the command of sovereign. He believed that in society, subjects are bound by the command issued by the sovereign from time to time. In the Indian Constitution, state is vested with sovereign power as outlined in Article 21. It is the regulating power of the state to make laws to preserve public order, comfort, general welfare and safety of its citizens. This is what exactly Your Lordship the state did. If there is a disruption of peace and tranquility, it threatens the very foundation of the democracy. Your Lordship, the regulations were formed with the sole intention of maintaining the public order and preserving the peace of the state. If Your Lordship may refer to page 3, para 3 of the Moot proposition.
Before we start the next question, one question is there. In the facts of the present case, she has been acquitted. She has been acquitted of the charges. Does she not have the right to expand those proceedings, or at least kept under the seal cover for that purpose? Because ultimately she is a woman and his rights are to be affected, as has been affected for the marriage prospects.
Your Honor, in section 327 of the CRP, which states that court has to be open. It is essential for the citizen to know about the potential threat around them. The erasure of the past criminal records, Your Lordship, would lead to a dire consequences.
As the single act on behalf of a person, he should be treated as a criminal for all times.
Your Lordship,
That's maybe depending upon the various circumstances. In this case, harassment of the person by that Amruta also and the Bajirao also.
Your Lordship,
They have a motive also to involve her.
Your Lordship, the counsel understands the concern of the bench, and Your Lordship, the counsel totally agree that what Bajirao did was totally wrong. It was totally wrong the way he harassed Sachibai. But Your Lordship, I am the representative of the state, and my duty is to protect the state and not Bajirao. Your Lordship, what Bajirao did by harassing Sachibai, it was his own personal interest, and it has nothing. The action didn't happen in the course of duty or course of employment of Bajirao.
Why the charge charge sheet was framed against her. Charge sheet was filed with OC court and actively prosecuted. While the state did not take action against the investigating officer, who has already a warrant, this is an investigation.
Certain Lordship, if your Lordship may refer to page 2 of the Moot proposition, it states that Bhajilo had every reason to believe, and he has investigated it in a thorough manner, and he had reason to believe that Sachi Bai could have been involved in that particular offence, and this was the reason that he filed the charge sheet against him. It is also
Look at the first line of the trial, page 2 of the proposition. Here is the timing mentioned. This is all a circumstantial evidence. Read the line. Trial prolonged morning of 28th of January.
on the morning of 20th January 2022, Mr. Amuja was found dead at the SHAKUNTALA branch of exhilarating IAS. He was stabbed multiple times. The cause of death was reported to be excessive bleeding caused by the stab.
How it happened, who have last seen anything.
Your Lordship, in this particular para, the facts are cited about this, and it can be concluded, it cannot be concluded whether the investigation was done in the proper manner or not. I have stated that why Sachi Bai will come forward, why the state will protect Sachi Bai from the harassment of Bhajilo. Your Lordship, Sachi Bai didn't come approach the honorable court and have said didn't come file an FIR regarding the harassment part.
He has approached that this act is null and void, unconstitutional.
Your
My
Lordship,
right is affected.
Your Lordship, the right to be vigilant about the potential threat underlying the society. Your Lordship, the state condemns any such action, and Your Lordship, the state is stating that we are acknowledging whatever has happened with Sachi Bai when she was harassed, when Bhajilo went to Manoj and stated about certain things to Manoj,
Can
and
the state explain what is the other evidence except this case against her that she should be hauled up as a criminal for all time? Except this single act.
if Your Lordship may refer to page 2 of the Moot proposition, page 2 and para 2 of the Moot proposition, it states that Mr. Sunday, when Mr. Sunday was one of her batchmates, and when he went to witness the plight of Sachi Bai, Mr. Sunday, it is stated, Mr. Sunday came and sat next to Sachi Bai and tried to inquire if she was doing okay. Your Lordship, he just wanted to, with good intent, he just wanted to inquire, he just wanted to know about the health of Sachi Bai. Your Lordship, but what Sachi Bai did, she shouted at him and pricked his hand with a pen multiple times. Your Lordship, this was the reason Sachi Bai's history sheet was accessed, because she had the potential to be a threat to the people.
Did this Mr. Sunday ever complain regarding the incident of that?
Your Lordship, the facts are silent about that particular part, so it cannot become say.
This is not a bench. The only issue was criminalization was with regard to death of police officer.
But Your Lordship, the opening of history sheets are highly required since Your Lordship, if we understand it in the layman terms, if we delete all the data, it will lead to a huge demand and it will create a Pandora box. Things will get too chaotic, and since we are in a law profession, we will be the future lawyers of our country. Your Lordship, the main source that we use to access information is SCC or Mufadra and case file and other things. Your Lordship, we won't be able to access such information in a very informed manner. And Your Lordship, there's a very thin line between the right to be forgotten and right to the information.
Can you show any protection provided under this UP Police Act 1949 and the regulation 2023? Any protection for the individuals who are to be branded as criminals?
Your Lordship, their protection to them shall not even be a question, because Your Lordship, the regulation which are 199 and 200 are solely talking about opening of history sheets of the person And whatever has happened after that, the actions of Bhajirao, alleged actions of Bhajirao, that he has installed M-Spy and surveyed around Sachibai. Lordship, that again I would like to contend that that was not done in the course of employment of Bhajirao. Lordship, the liability of the state cannot be attributed as the actions of Bhajirao was not made on the behalf of the state. When he went to her at the odd hours, again it's edited, when he went to Bhajirao and when he went to Manoj and stated that she was suffering from alleged HIV disease. Lordship,
what is the meaning of has the potential to become a habitual offender? What is the evidence regarding this?
Lordship, the evidence regarding this would be, firstly, the crime that she was acquitted in, and second, the Mrs. Handy's case. These two cases, and firstly, as it is stated in page 2 of the first paragraph of the proposition, that Sachibai.
Does any person, any man, have the right to go and sit next to a person and make inquiries against her wishes? As you said, he was only being nice, he wanted to know about the well-being. But if the woman doesn't want someone to sit next to her and ask about her well-being, can a person force himself on her? Not.
Your Lordship, but we agree, we are from the very start of we are stating, we are agreed that what Manoj did when he did everything to Sachibai was completely wrong from the very start of it. But Your Lordship, I as state, I am just saying that state cannot be held vicariously liable in this part, as it can be also supported by the case, which is State of Odisha versus Padmalochan. In that case, Your Lordship, it was held that the police personnel committing excess in the discharge of their function without authority would not take away the illegal act from the purview of the delegated sovereign. And Your Lordship, in this case, it was held that the state will not be held liable for the cases or for the act that was done by the police personnel. So, Your Lordship, in this particular case too, the state shall not be liable. Bhajirao shall be liable, and new investigation should be opened in this particular part regarding Bhajirao.
Benches of the tentative rule. Expunged or sealed, subject to your argument defendants. Bench is considering the contention of the petitioner and is tentatively of the view that this remark should be expunged from the record of the case, or at least it should be sealed for the time being.
Give her 2 more minutes to answer the question.
Because you are a state, this is the issue of the personal privacy and other things of the and marriage prospects of the petitioner. So you will have to at least satisfy the bench with regard to this.
The council will be throwing this.
Still 5 minutes more. Next time.
The fear that state has not been there. Right, tell us on facts the bench may see the legal position.
Lordship, the regulation which was passed, the regulation 199 and regulation 200, which was regarding the opening of history sheet, was done with the sole intent to protect the order of the state, and as it is also mentioned in the proposition.
In the interest of public at
Exactly.
large and
Certainly, Lordship. In the wake of increasing crime, it was so the sole purpose of the regulation was to ensure public order. Your Lordship, the regulation which was put under this, the regulations which are being put under this act are proportionate to its object, since Union of India, the test of proportionality, the doctrine of proportionality got established, and the apex court laid the test that the legislature has to follow, which is legitimate aim, rational nexus, necessity, and balancing. Your Lordship, here in this case, the restriction has a legitimate aim and necessity, which is to control crime and ensure public order. It has a rational nexus, Your Lordship, as to the restriction on the right.
I think Justice Dhaliwal's question was, we propose to expunge the history sheet. So far as this petitioner is concerned, so far as Sachibai is concerned, what do you have to say to that?
Your Lordship, we cannot completely delete this particular part, Your Lordship, because the intent of the law was welfare of the people, was to regulate crime, and Your Lordship, and
The intent of the law may have been all right, but we propose to expunge the history sheet so far as this particular case is concerned. So what do you have to say to that? How do you answer? What is your answer to that?
It has the potential to become a habitual offender. You tell us the evidence on record, on the basis of fact, that she can be a potential offender.
Your Lordship, as it is stated in page 2 of the Moot proposition, para 1, that she became extremely distraught and stressed after the harassment by Bhajrao and after the harassment of Ambuja Pant. She got extremely distraught and stressed. Her behavior towards her mother and peers significantly changed, and she got highly provoked and angered by even the sight of man. And Your Lordship, after this particular part, it is stating that when Mr. Sunday went to visit him, she pricked his inner hand. Your Lordship, how can such a person who, when get agitated, some people who, when get agitated, is a harm to the society, shall harm to the society, and her history sheet shall be deleted because
Is such a person a harm to society, or does such a person need counseling? Is making a history sheet and spoiling the person's career the option, or should a person be sent to a experienced counselor?
Your Lordship, what you are stating is completely all right, but Your Lordship, state could have helped her if she would have approached the state regarding her problem, regarding her grievances, regarding Bhajrao and the harassment part, and how regarding the everything, she should have approached she should have approached the state and filed an FIR, but she didn't. And state couldn't.
When you state they say that we are let the representation be moved by her for expunging and sealing of this. Why you have not straightway come to this? You have started arguing that this should not be done. And at the outset, state should have said, no, we will consider that the representation is done.
If Your Lordships, if Your Lordships agree, shall I start?
Yes, come up.
Your Lordship, the restrictions that were imposed on Sachibai were reasonable restrictions, since in the case of Swami versus Union of India, 3 tests were laid down on right to privacy, and since right to forgotten is part of right to privacy, the restriction will be equally applicable here too. It has legitimate aim, proportionality, and legality. It has a legitimate aim, as I mentioned before, it is made to ensure public order and regulate crime, and it is proportionate to its object, as I have already mentioned, and it is legal, as Bhajrao was authorized by the improved regulations. And Your Lordship, moving on to issue 4, that did Sachibai has right to marry in a case that override a potential spouse to be protected from deadly disease. Your Lordship, in this particular case, here, in the case of Supriya Chakraborty versus Union of Lordship, the right to marry is a fundamental aspect of personal autonomy and individual liberty, allowing individuals to decide whom to marry. The right to choose a marriage partner is equally given to both Manoj and Sachibai. Lordship, here in this particular case, as a potential spouse, Manoj holds the autonomy to make decisions regarding his marriage based on his own preference, values, and consideration. When Manoj refused to marry Sachibai, it was his personal choice. Manoj's right to marry included the right to make decisions based on relevant information. Manoj's choice reflects his own desire, indicating his personal preference not to marry Sachibai. Lordship, proceeding the second argument. Extending 30 seconds. One more part. Your Lordship, the actions of Bhajirao were made in the course of duty. Bhajirao was acting under a belief that he was obligated under section 269 and 270 of IPC, but the same require investigation and procurement of the evidence which is absent right now. Hence, the Lordship, the liability of the state for the acts of Bhajirao must not be invoked primarily due to two reasons. Firstly, whether the acts were illegal, unlawful, and amounting to offence require consideration by trial court. Such examination by trial court is absent in the instant case. And secondly, Your Lordship, even in the acts of Bhajirao illegal, they were performed under a personal capacity with no link connection with the state, and hence liability of the state shall not be invoked. The council seeks permission to commence with the Therefore, may it please the Honorable High Court of Uttar Pradesh. In the lights of issues raised, argument advanced, and authorities cited, the respondent most respectfully prays that this Honorable Court may please to dismiss the petition, uphold the constitutional validity of Section 46 of the Uttar Pradesh Police Act 1949 and Uttar Pradesh Crime Control Regulation 2023, and/or pass any order, direction, relief that it may deem fit in the best interest of justice, equity, and good conscience, all of which are respectfully affirmed and submitted. The Council on the Lordship, it is an honor to plead for the Honorable.
Your Honours, the Council only has two small submissions to make, Your Honours. Your Honours, firstly, the incident with Mr. Sunday, Your Honours, a little bit of background here is necessary. Your Honours, this was following the subsequent harassment by both Mr. Ambuja and Bajirao, Your Honours, when Bajirao's offer of marriage was refused. Furthermore, Your Honours, nowhere in the factual matrix does it state that Bajirao was present when Mr. Sunday was pricked in the hand, Your Honours. Therefore, Your Honours, Bajirao had no knowledge, according to the factual matrix, Your Honours, of such an incident ever happening. Furthermore, Your Honours, no criminal charges were pressed on Sachibai for committing such an act. Therefore, Your Honours, the Council would humbly contend before the Honourable Bench that this does not constitute a potential offender, Your Honours. Furthermore, Your Honours, my learned opponent co-counsels themselves stated that Bajirao made those statements when he informed Manoj of the high risk of sexually transmitted diseases in the course of duty, Your Honours. Therefore, Your Honours, the state will be liable in the case of a fundamental breach of a fundamental right, Your Honours. The Council.
You have already invoked the Article 226.
Indeed.
With regard to when you are challenging the violence of the Act, you have not asked for the supervisory jurisdiction under Article 227 of the Why you have not pleaded for that?
Indeed, Your Honours, the Council would humbly
You have
apologize.
read the Article 227 of the Constitution.
Your Honours, the Council would not venture into a guess, Your Honours. The humble apologies for the same, Your Honours.
You have mentioned you have to send
Your Honours, the
argument by
Indeed.
supervisory jurisdiction.
Your Honours,
Anything may not be said, you will have to go at your own regard.
humble apologies for the same, Your Honours. Much obliged.
The event is a testament of the deep commitment of the School of Law, Galgotias University, to develop critical legal acumen amongst its students through the moot court exercises that are the cornerstone of legal education. The Srimati SHAKUNTALA Devi first National Moot Court Competition is named after the enterprising patron of Galgotias University, a woman who envisioned education as empowerment for all. This marked the flagship of the ever-first National Moot Court Competition hosted by Galgotias School of Law to provide an enriching platform for young students at the university and beyond. The past 3 days have seen the intense enactment of challenging the advocacy skills of the future lawyers of our country. The Srimati SHAKUNTALA Devi first National Moot Court Competition witnessed the participation of 22 teams from both the international and the national territory.
It is a matter of great pride to be in the distinguished presence of Honorable Justice Paramjit Singh Dhaliwal, Sir. May I please request Justice J.R. Midha, Sir, Professor Emeritus, School of Law, Galgotias University, to present a bouquet to Justice Paramjit Singh Dhaliwal, Sir, for gracing us as the guest of honor at Galgotias School of Law.
Of Law and all the participants are enamored with the majestic presence of Honorable Justice Ms. Indira Banerjee here with us today. With a sense of sincere humility, may I please request Mr. Sunil Galgotia, Chancellor, Galgotias University, to present a bouquet to our Chief Guest, Honorable Justice Ms. Indira Banerjee, for blessing the first Srimati SHAKUNTALA Devi National Moot Court Competition 2020.
Thank you, ma'am. Proceeding with the intricacies of law and to lighten its wisdom, may I please request all the honorable dignitaries on the dais, Honorable Justice Indira Banerjee, ma'am, Honorable Justice Paramjit Singh, Sir, respected Sunil Galgotia, Sir, Chancellor, Galgotias University, respected Dr. Renu Luthra, ma'am, Advisor to Chancellor, respected Dr. Naresh Vath, Sir, Dean School of Law, and all other respected dignitaries to please come forward for lighting of the lamp.
for 13 years and is currently the Professor Emeritus at the School of Law, Galgotias University. Sir has been involved in initiating various student-centric law-based programs at our department. May we please request Sir to deliver the opening remarks for this session. Sir.
रिकॉर्ड नहीं करना
Honorable Justice Indra Banerjee, Honorable Justice Dhaliwal, Honorable Justice Indra Banerjee, Honorable Justice Dhaliwal, Sunil Gargotia ji, Mr. Naresh Vats, Renu Luthra ji, and all the teachers and students present here. I am delighted to be part of this program today, and I am very glad to be with Justice Indra Banerjee. We were together in Delhi High Court for some time, and had a very good time in Delhi High Court. Although we did not share any bench, we were contemplating to share a bench, but somehow could not. So today is the opportunity that we are sharing a moot court today together on the bench. I am very glad to see the wonderful performance of the students. Both the teams were extraordinarily good. But I have little different views on moot court, which everybody is aware. I have given my views number of times.
रिकॉर्ड नहीं करे थे
You see, 90% of the cases are based only on facts. Only law
भैया,
comes quite late.
बैठ जाइए था
And-
आ ही रहे कैमरे में
And 0.001% cases are where the law is challenged. The wires of a law is challenged. So moot court problem, to my mind, I always shared that platform. It should be factual based. Simple facts where all the audience, everybody should be are able to, and the both sides should be equally should have equal opportunity. Both views should be equally possible. So because at times what happens is that if one side is little stronger on facts or law, then he gets an edge in making arguments. So I always, whenever I get an opportunity, and I had shared this with Mr. Vats also, that we should have very simple factual problem on facts. And whenever all the young lawyers join, they all will have cases, no specific performance, where there is a breach of agreement, loan agreement, check dishonor case, trademark violation, right violation. Beyond facts, the answer will come, and come from a logical reasoning. Ultimately, it is a logical reasoning which develops, and ultimately, and challenging of wires is something very rare. In my 30 years of practice before elevation as a judge, I didn't have any opportunity of challenging the wires of any law. So, but still with such a complicated problem, the performance of the students, both the teams were extraordinarily good. I must compliment them. They have outperformed them. When I saw the problem, I was wondering how the students will be able to perform, but they have performed very well. And I'm very glad to see such a wonderful participation and everybody here. And I'm part of Galgotia University. This is my 3rd year because of my passion for teaching and reforming legal education. And I think I still have 2 minutes. I'll share my thoughts on legal education. You see, most important skill of a lawyer is communication skill. How to communicate. And if the communication skill is lacking, then even if you know the 100% law, still you will not get the result. Second most important skill of a lawyer is rational thinking. How to think logically and find a logical answer. So even if you have wonderful communication skill and also 100% knowledge of law, but rational thinking is missing, then also everything is multiplied with 0. Third important skill of a lawyer is to understand the fundamentals of law. So a law student, you have to go backward and see what was the position when this law was not there. What was the first case which arose? Where it arose? Why this law was framed? What was the object of this law? For example, trademark law. There was a time when there was no trademark law. Then in one particular country, one particular case arose and the government framed the law. From there it traveled to other countries. Then it came all over and it was framed. It was a very primitive, defective law. Then what was the object? What were the defects? How it was cured? So once we understand the fundamentals of law, and that comes from the basic problems and what problems we wanted to cure, once you have that understanding of fundamentals of law, then you understand the law better in and out. You don't have to then remember anything. You understand it. Then also lawyers should have some amount of dramatic skills also. Ultimately, you see all the top lawyers, they've got some dramatic skills. You know, when we multiplied Justice Nageshwar Rao at his retirement, he said that as a lawyer he was into theatre, and that helped him in his performance as a lawyer. Then also some amount of psychology, art of reading the mind of the judge, of the opposite counsel, and also understanding the psychology. So all these skills are necessary. So only knowledge of law will not get you the result. Even if you have 100% knowledge of law, but communication skills are lacking, everything is gone. If rational thinking is lacking, then everything is wrong. So all these law students should emphasize on developing all these skills so that you attain perfection in legal profession. So thank you very much for being here and participating. Thank you.
Thank you so much, sir, for having your heart in the right place for the students always. Many thanks to you. The Dean School of Law, Professor Dr. Naresh Kumar Vats, is a seasoned academician under whose expertise and leadership the Galgotia School of Law has initiated this competition. And sir will present the detailed report of the Moot Court Competition.
I'm sorry, because of the time constraint, I intervened in between. Very good evening to all. Jai Hind. The Galgotia University School of Law welcome Honorable Miss Justice Indra Banerjee, former Judge of the Court of India, and her kind consent to be the chief guest of the first National Moot Court in the memories of Srimati SHAKUNTALA DEVI. And Honorable Chancellor Sri Sunil Galgotia ji for his kind consent, whose visionary and the dynamic leadership and the pillar behind this whole show is his vision, for his kind consent. And Dhruv Galgotia ji, Chief Executive Officer in his absentia, and Miss Aradhana Galgotia ji, Director of Operations, who is directly looking after the School of Law in her absence, and in presence of Professor Renu Luthra, who has been doing wonderful and supporting the School of Law, ensuring it's a smooth functioning of the School of Law. And Honorable Justice Paramjit Dhaliwal ji, former Judge Punjab and Haryana High Court. I'm fortunate to have him here. After a stay in US almost 1.5 months, day before yesterday, I just had a contact with Lordship, and Lordship kindly consented to be here. Thank you, sir. And Justice G.R. Midhaji, former Judge Delhi High Court, is continuous support, and without any hesitation, he just expressing his consent. Naresh, I'm with you. Thank you, sir, for your kind consent. I also welcome the dignitaries on the dais and off the dais on behalf of faculty, School of Law, members, students, Moot Court Society, and the faculty. Day and night they had been working. 22 teams participated across the country, representing the very renowned institution, and by eliminating from the preliminary round to the quarter and the semi-final, and we are having the two teams now present, to which the result is awaited here. From respective institutions, from the National Law University, Punjab, AIL Mohali, even GNU, Amritsar, and many other renowned institutes, they are here. So I am highly obliged and thankful for all the participants representing this event, for the active participation and ensuring the smooth conduction. And I own the responsibility if at all some lapse happened in the hospitality of my students and the delegates. My students and the faculty member, they have been doing wonderful, but still I own the responsibility, excuse me, and for the next time, if at all some lapses are there, we will try to raise that. Many thanks. Without the constraint of the, because of the constraint of the time, I will not be having that much time, and I request the house to please continue. Thank you. Good luck for that.
Thank you so much, sir. It is truly a privilege to mark the presence of an electrifying individuality. Justice Dhaliwal, sir, garnered huge experience as a practicing lawyer before being elevated as a judge of its High Court, which he served with his unparalleled judgments until his retirement. Sir has truly set a precedent for all these students to believe in an old saying, education has no bar of age. This passion has led him to enroll in the doctorate program. Currently, Justice serves as the President, State Consumer Disputes Redressal Commission, Punjab. With all my sincerity, may I kindly request Honorable Justice Paramjeet Singh Dhaliwal, sir, to kindly bless our students.
Invited me for this, the university, for attending this function. It's my privilege that I have to share the bench here with sister Indra Banerjee, Justice Supreme Court, Judge Supreme Court of India, former Judge Supreme Court of India, and brother Mida. We had earlier met in Rajiv Gandhi National University. I also thank Mr. Sunil Gurtaji, the Chancellor of the University, and Madam Renu Luthra, that she told me that keeping in my background, you must encourage the students. How you had come from a small village and elevated as so I must narrate about that also, because she suggested that it will be an encouragement for the students of law who had come from a humble background or the rural areas. First of all, I will say today is a very lucky day, very auspicious day. Today is the birthday of Shri Guru Tegh Bahadur, and who have fought for justice. Everyone knows they are known as Hind Di Chadar. When Tilk Janju Extra was being asked to move, and they sacrificed his life, and that is what we are here. You are a just student of law and must be doing some justice in future, and you are budding liars and future of the country. This came to my knowledge when I started getting messages on the WhatsApp that today is a birthday of Shri Guru Tegh Bahadur, 9th Guru of 6. So this is relevant because they have always said that justice must be done so that people can freely enjoy their faith and practice the same. So without going into further details, I will say that so far myself is concerned, I started my career as a technical assistant after passing the BSc Medical in a Punjab State Warehousing Corporation. I did law in the evening classes. Thereafter, I joined practice at Subdivision Mansa. I am fortunate that I have attended from the lowest court of the country to the highest court of the country in foreign countries. I happen to be in a Canadian court. I was just a visitor, and I was invited by the Superior Court, which is equivalent to the Court of Session Judge here, and I have to call with regard to the customary concepts, Chadar Andazi. This was a practice prevalent at that point of time, and in some cases here presently also. With regard to the marriages, with the once there is a death, then the younger brother, and the purpose is to keep the family intact and the property intact, so that if there is no property still, so that the kids may be brought up in a proper manner. Leaving aside all these things, it is a long history. I resigned from my post as a technical assistant and joined service after 2.5 years, because the circumstances were such that without this job that I would not able to, may not have gone to further studies. After 24 years of passing law in 79, I did LLM. That was distance education. Again, after 24 years, now I am doing PhD in standard form control. This is the last step, and I am continuing other things also besides this. So, this is my brief in career. I will request you what are the fundamental three things which you must try. You must be knowing the word rise or rise. These are very important in the life of a person if you want to be an excellent. When we take the alphabets, R represents respect. In the profession, first thing is profession, this respect. Second thing is I. I represent integrity. Integrity of a person is more important for this profession. This is not a profession of lawyers. It is actually a profession of professionals who are having integrity and doing justice to the parties and the court also. Then comes the C. If we take it as a rise, then comes the C. Then what is important? Confidence. If all three things, respect, integrity and confidence is there, then comes the E, then you achieve excellence. If we say about rise, then C is replaced by S. That is more important, that is also known as self-confidence, which is more important in the profession. So, these are the things. There is a saying when you go to the courts, how the justice is done. The three C's are also important. First important thing for a professional as a lawyer, as an advocate, is that you must convince the bench. If you are not in a position to convince, then confuse the bench. If still there is some problem there, then I would not say that that seat is also used for that purpose. You say corrupt the judges to get justice. This is common practice in the lower courts, how they can do this. I am telling you the practical, what is happening. In these circumstances, we will have to grow in the field, but my sincere advice is, you are not supposed to look into the third C which I have mentioned. First C is more important. Convince the judge with your argument. So, I would say life is very simple. How it is complicated? Complication arises only with the thinking. So, keep your thinking simple and do your hard work. So, when we are looking into this profession, what we have to do? Hard work is the key to success. So, remember these words, rise and rise. I hope that you are a budding lawyer. Your future is on your shoulders. I certainly hope that whatever we have seen, moot means open to discuss. So, when we talk of the moot courts, that is the open forum before discussing before the audience also, before the benches also. So one thing is very important. It is difficult to speak when you are facing the audience. Lawyer is the best person because audience is behind him. only the bench is before him when you are addressing. No hesitation should be there. Justice Mehta has explained that what are the importance, how do the facts, you should be master of the facts, and the law will come later because 99% cases are decided on facts. So I will suggest you only that you must not wait for the flowers will come to you. You will have to sow your own seed, automatically flower will come up and you will achieve in your life. You must have a motive, aspire and achieve. Unless you aspire, you cannot achieve. Thank you very much. Thank you.
Now we feel so privileged to have amongst us the inspiring presence of Honorable Justice Ms. Indira Banerjee. It is especially extraordinary to reiterate that as a first-generation lawyer, she has breached many glass ceilings to rise to becoming only the 8th woman jurist to enter the hallowed halls of the Supreme Court of India. In addition to her enhanced sensitivity towards the protection of dignity of children in Gangadhar Narayan Nayak versus State of Karnataka, she has been a torchbearer of equal protection of human rights. Honorable Justice Ms. Indira Banerjee is an example of what women in positions of rendering justice can accomplish for the women of the nation through the part she essayed in cases related to Muslim women's rights, the anticipatory bail question in the Triple Talaq case, and the consent of women in sexual relationships, ensuring legal justice while busting lifelong societal myths along the way. Honorable Justice Ms. Indira Banerjee has been a stalwart figure, serving the nation with a conscience of both the letter and the spirit of law. May we please request ma'am to honor us by addressing us with a few words of her wisdom.
Justice Dhaliwal, former judge of the High Court of Punjab and Haryana. Justice Mehta, former judge of Delhi High Court, and my former colleague, not just my former colleague, also my spiritual mentor, Mr. Sunil Galgotia, Chancellor of Galgotia University, Mr. Naresh Bhatts, Dean of the Law School, Professor Renu Luthra, the members of the faculty, the students, the participants, ladies and gentlemen. I consider it a privilege to be here on this wonderful occasion. And I have my own reasons. The person who was telling you about my background mentioned that I was the second woman to become Chief Justice of Madras High Court, 8th woman to become a judge of the Supreme Court. People mention this as though it's a feather on my cap. But this is something which really pains me and upsets me, because I was appointed to the Supreme Court 68 years after our Constitution came into force. And when I was appointed Chief Justice of Madras High Court, Madras High Court had a history of, I think, 100 and 55 years. So in a history of 155 years, until date, Madras High Court has had only 3 women who have been appointed Chief Justices. I am absolutely thrilled because this moot court competition is in the name of Srimati SHAKUNTALA Devi, an outstanding lady. I was amazed by the performance of the participants in the moot court today. But what I felt very happy was that there were 5 women with 1 woman, 1 man. The legal profession has always been considered a men's bastion. I can see very competent women coming into the legal profession who would set right the imbalance very soon. In India, we have a constitution. It is the basic law, the architecture of the polity. Indian polity is based on the constitution. So I'm glad that the moot court contest, at least this session, is based on the Constitution of India and on constitutional issues. Unlike Justice Litter, I started my career and I made a mark in the career with some important cases, one of which was Lakshmi Mani Dasi versus the state of West Bengal, where the vires of the Calcutta Thika Tenancy Act was under challenge. I was junior to Mr. Espal. Many of you may have read his books on public service, on the Constitution of India, and the contempt, the law of contempt, and so on and so forth. And it may be of some interest to many of you that he was, unfortunately he passed away last year on 9th March. He was the better half of my predecessor in office and mentor for all practical purposes, Justice Rumapal. When I joined the chamber of Mr. Pal used to say, when your facts are good, the court will try to stretch the law in your favor. If your facts are bad, the court will try to bend the law against you. So I repeat what has been stated by the previous speakers, both seasoned judges, that you should concentrate on the facts, explain the facts, and then go on to the law. The second thing is, when you cite a decision, you should know what that judgment has held. It doesn't help to read textbooks and see commentaries and just say, in such and such case, this has been held. You must remember what constitutes a precedent. A judgment is a precedent. for the issue of law which is raised and decided, and not that which can be logically deduced from the judgment. So in the given facts of a particular case, when a particular law is under challenge, a judgment may have been rendered. In its reasoning, a judge may say a lot of things. What the judge says is not to be read in the manner of a statute. Remember one thing, when the legislature enacts law, there are a lot of deliberations, discussions. But when a judge is dictating the judgment, it can even be dictated offhand. There are many oral judgments. And today particularly, judges are extremely hard-pressed for time, because I'm sure you keep reading in the papers, you hear of discussions about the huge pendency of cases in different courts all over the country. In fact, in a lot of cases pertaining from Uttar Pradesh, there used to be applications in the Supreme Court for suspension of sentence on the ground that criminal cases were pending for years. And there were so many cases where either the accused went scot-free, or the accused spent the entire sentence before the matter could at all be decided or heard. Now, coming back to the Constitution to which I referred, it is the basic law. In India, we have a people-centric, egalitarian Constitution. The people of India have constituted India into a sovereign democratic republic. Today it is a socialist, secular, sovereign democratic republic. It promises to secure to all its people justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote amongst all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Integrity has also been incorporated by the 42nd Amendment Act, like the expression secular and socialist. The preamble beautifully summarizes the objects of our Constitution. The elaboration is to be found in the fundamental rights, on which a lot of arguments were advanced by the participants today. Then, of course, you also have the directive principles of state policy. But it is important to remember the caution of B.R. Ambedkar, who is considered as the father of the Constitution, the chairperson of the drafting committee which drafted the Constitution. He had said, a bad Constitution can be made a good Constitution if the people responsible for working of the Constitution are good. And a good Constitution may become so good constitution if the people responsible for working the constitution are incompetent, if they do not value principles of constitutionalism. In the Indian polity, the judiciary is a very important pillar of democracy. We have separation of powers where the legislature enacts the law, the executive executes the law, and the judiciary interprets the law. For giving effect to the vision of the Constitution as summarized in its preamble, which, to quote Justice Madholkar, shows deep deliberation. His quotation in the case of Sachin Singh. To give effect to this vision, we must have a strong, independent judiciary. We must have men and women of integrity. I see amidst you the students present before me today, the future of the Indian judiciary, the future of the Indian country. And that was precisely the reason why I readily agreed to be here today, in spite of a commitment which I actually had to reschedule. I still remember when I first appeared in a court way back in 1985. My throat was scorching. I was perspiring. In spite of all the public speaking that we did at school and all the debates that we participated in, you know, the sight of lawyers in their robes, a stern judge up there, the High Court building where I started my practice, the Calcutta High Court with its arches and pillars, it was frightening, if I may use that expression. But what is the advantage that you students are getting today? You are getting the practical experience of addressing courts. And I'm sure you are also taken for court visits once in a while. So when you visit courts, you get the feel of different courts. And when you participate in the moot courts, you get the feel of addressing judges. In this case, all three of us were judges of constitutional courts. And look at the questions which were put to you. I was simply amazed. Would I have tackled the questions in the manner that you did today? Possibly not. Possibly not. What are the advantages of mooting? On this occasion, I cannot but remember Madhav Menon, Professor Madhav Menon, who is considered to be the father of mooting in India, and who also changed the law law education, he changed law education in this country. I still remember when I joined the law college, which was of course the Calcutta University College of Law, which did have a repute once upon a time. Law was a very neglected branch of study. There were scathing remarks made by law commissions against the state of law education in this country. It pains me, I would rather not refer, or I would rather not quote what had been said by the law commissions. Thankfully, things have changed. Today, law education has become highly competitive. More and more students are doing law. You have difficult admission tests to clear, and the quality has improved. First of all, moot courts give you the confidence which was spoken about to address the court. So while you are students, even before you actually start practice, you become confident. It helps you to prepare thoroughly so that you can tackle all questions which may come from the bench. You may sometimes wonder, why did the judge ask this question? The judge may have his or her own reasons for asking the question, and that question may even be to test you, to see how you tackle the question. So you may think that, is this the correct proposition of law? But the question is put to you so that you can tackle and say why the proposition is not correct. As pointed out by my previous brother judges who spoke, what makes a good lawyer? There is no alternative one to hard work. There is no alternative to reading. My senior had advised me, don't read just the head notes in a judgment, because head notes is something that is prepared by the editors, by the reporters. Read the entire judgment, see the facts, and see how the law has been laid down. You have the ratio decidendi in a judgment which constitutes a binding precedent on subsequent courts. That is the issue and the answer to the issue involved in a particular litigation. Casual observations may have been made. Other legal issues may have been discussed in a judgment which may not have pertained to the case which was being decided. Now this would be obiter. But the Supreme Court has again said that even observations of the Supreme Court which are obiter are to be respected. So you cannot ignore them altogether. Very often you find that the best students legal profession. And you also hear of great judges, great lawyers, who may have been very ordinary students in their student days. What is the reason for this? What was referred to by my previous speakers was advocacy and courtcraft. How you present the case before the judge, how you field the questions. And these moot courts, you know, I was just hearing ting ting, time is over. So it teaches you the art of time management, which is extremely important today, particularly with the pressure on the courts. So if you start off narrating the Ramayana, the judge will get impatient. So you have to come to the point, explain the facts, come to the point, explain the law, and cite judgments which are relevant and to the point. If you cite too many judgments, many of which may not strictly be applicable, then the judge may lose track of the more relevant judgments which you cite. After all, judges are also human. And you must have heard of the expression that the Supreme Court is not infallible. It is the final court, but not necessarily infallible. Yes, it applies to other courts as well. Only that there may be another court in the hierarchy to which the litigants can go. Apart from giving a lot of time to the profession, reading, you should acquire the art of time management, not just for making submissions, but for preparing. You have to divide your day. A considerable part of the time you will be reading, preparing your briefs, but you have to make sure that you have to keep some time, maybe for a walk, maybe for a little bit of meditation, which calms the mind. Now, coming to meditation, why do I say meditation? Because the legal profession is also a taxing profession because of the competition, particularly at the early stages. When you come to the court, you're running from court to court, maybe briefs are not forthcoming. You get your first brief or your second brief. You appear in a court, and the court straight away dismisses your petition. You have to take these things in your stride as part of the game. They do not necessarily reflect on your performance. I'm sure today there will be a winner and a loser. But that would probably depend on the merits of the case, more than what has been done by the parties. What is important is to participate. It doesn't really matter whether you win or lose. I've spoken beyond the time allotted to me, though I'm the one who kept saying that I have another appointment after this for which I'm in a desperate hurry. I congratulate every one of the participants. You were absolutely amazing. I was floored by your performance. And assigning marks to the participants was more difficult, perhaps, than most of the judging that I have done in the course of my judicial career. Because the participants were so close to each other. Do not be disappointed if you have not made the mark this time. You may the next time. Those of you who have made it to the top are definitely good. But that does not mean that those who miss the mark are any less. There is always scope for improvement. Now, one last thing which I would like to advise you. I was just talking about the judiciary as an institution, the importance of independence of the judiciary, and the importance of judicial excellence. When can the judiciary be truly independent? When the judges are courageous, they are persons of integrity, there should not be any block mark in the career, and they should have their basics clear, they should have good knowledge of law. And there is also perhaps a fourth thing, that they should not be too ambitious. These are important qualities which a judge must have. But when we talk about the judiciary, is it only the judges we are talking about? Speaking for myself, I can say that most of the good judgments in the course of my career, including the Constitution Bench judgment authored by me, in which I set aside the Chhattisgarh Rent Act as unconstitutional. Ultra vires the Constitution of India. In order to do well, I was talking about the integrity which you must have. Yes. How did these good judgments come? It was because of the assistance which I got from the lawyers. I can't deny the assistance which I got from the lawyers. So it is you lawyers who will be able to ensure judicial excellence, that the judges deliver good judgments, and that they do not breach the principles of judicial integrity and independence. I also appeal to some of you to join the judiciary. Please take the judicial service examinations, because we do need good judges. So this is all the basic advice that I have for you. Please do not get deterred. If you belong to the first generation. I was a first generation lawyer. Though my father had an LLB degree, he was an IPS officer who was long retired by the time I joined the profession. So I did not have that kind of backing. I was enrolled in 1985. I was absolutely thrilled in 1989. During the Puja vacation in Calcutta High Court, we have long Puja vacations. And in those days, you didn't have mobile phones, so we used to talk on the telephone for hours. During holidays, I was talking with a friend of mine, probably for 2 hours, because my parents were not in town. Just when I put the phone down, there was a phone call from a solicitor, a reputed solicitor, with offices in Calcutta, Delhi, and Bombay, saying that they used to call me Didi. Didi, you have to go to Delhi on Monday to the Supreme Court because the client wants you. The client is insisting that you should be briefed. I did not have direct clients. I was a member of the Bar Library Club. I had to be briefed through solicitors. But I remember the great feeling when this happened. So I assure all of you, if you try hard, if you read, don't get upset, show some patience, you will undoubtedly succeed not only succeed in the profession, you go to the top. There is always room for the good, for the hardworking, because as you can see the number of pending cases.
May I please request Honorable Justice Indra Banerjee ma'am to kindly announce and give away the award of winning team and bestowing the winners of the Srimati Shakuntala Devi First National Moot Court Competition 2024.
So it falls upon me to declare the winners of this contest. Let me first declare the runners-up. TC 16. TC 10.
Students are requested to please come up on the stage. All the respected dignitaries are kindly requested to join winning team will receive merit certificate, trophy and a cash prize of rupees 50,000 along with an internship opportunity at Scriptboard.
The management has also decided to give away a running trophy beginning this year. So for this 1 year, the winning team gets a running trophy which we will retain till the end of next year. Then we have the next Srimati Shakuntala Devi Moot Court Competition.
of the winning team kindly come up the stage.
This beautiful trophy in their hand is the running trophy. The winners have received the running trophy. Congratulations. Congratulations to the winners.
The award for the best memorial from the petitioner's side goes to Rajiv Gandhi National University of Law, Payal Singh, Vishal Chaudhary, Bhumika Grover. Students, kindly come up the stage. I request all the dignified dignitaries to kindly present the trophy and the certificate to the participants. The next award is for the best memorial from respondent side, and the winning team is Jamia Millia Islamia Faculty of Law, Mohammad Rashid Pradhan, Ishant Tripathi. Student, please be ready to come up on the stage. Congratulations.
The award for the best oralist goes to Anirudh Arora, Guru Nanak Dev University, Amritsar. Final award for the best oralist goes to Dhruv Kanuri, RV Institute of Law, Mohali. Come up on the stage.
Many congratulations to both of the oralists, Mr. Dhruv and Mr. Anirudh Arora. Heartfelt congratulations to all the participants and the winners, those who have participated in the first National Moot Court Competition 2024, organized by School of Law, Galgodias University.
We would like to inform everybody that the winners are also getting a
Winning team will receive merit certificate, trophy and a cash prize of rupees 50,000 along with an internship opportunity at Scriptboard. Winners will also receive a running trophy that they have already received and that they will be retaining for 1 year till the next National Moot Court Competition.
In addition to what the runners-up have received as their prize money, they will also be getting a subscription to EBC Learning, one of the partners for our event. Moving ahead, may I please request Justice J.R. Mitha sir to present as a token of our affection and gratitude to Honorable Justice Paramjit Singh Dhaliwal a small portrait.
May I please request respected Chancellor Mr. Sunil Galgotia sir to present a token of affection and gratitude to our chief guest, Honorable Justice Indira Banerjee.
Kindly stand up. Kindly rise, everyone. Again, a standing ovation. Thank you so much, ma'am. We truly appreciate your presence and guidance. May I please request Mr. Sunil Galgotia, Chancellor Galgotia's University, to present a portrait, a token of our affection to Justice J.R. Mehta, sir. With this glorious vision of India's future, may I now invite Dr. Smita Nizar, Associate Dean, School of Law, Galgotia University, to deliver the vote of thanks and address this magnificent gathering.
Congratulations to all. Due to time constraint, I should tell thank you all bye. But kindly let me take 1 or 2 minutes time to thank all our dignitary guests. With deepest gratitude and pleasure, I extend a warm and heartfelt thanks to all of you who graced this occasion. First and foremost, the Honorable, our Ladyship Justice Miss Indira Banerjee ma'am. And it was our privilege to get her as the chief guest to honor this occasion. Truly speaking, it's my personal privilege that she has agreed to become part of Disability Rights Clinic and to visit us at least once in a month to have an interaction of judicial wisdom with our students. Thank you so much, ma'am, for having all those invaluable time and sharing your wisdom and insights with us. Thank you so much. And we are so much privileged to have dignitaries like Lordship Justice Paramjit Singh sir. And this was an occasion to rethink how much humbleness we should maintain ourselves to be a dignified person. You made to think us that humbleness among the professionals, sir. Thank you so much for your invaluable time and the valuable ideas you shared with us and for sharing your personal professional experience. Thank you so much, sir. And the next in line is Honorable Justice Mehta sir, who is consistently with us. He is actually an internal honorable person for us, and I extend all our heartfelt thanks to Justice Mehta sir. And sometimes it is very difficult to measure the extent of formality we should maintain when we need to thank our own people who are the reason for us being here today. Honorable Chancellor Sri Sunil Galgotia sir, I literally speaking compelled him to be here. Then he said, okay, I will just be there. I told you your presence itself is very invaluable for us. And their unwavering support and commitment for the development of the School of Law is the reason for us to have this competition now. And we have no words to truly thank you, sir, but thank you so much from our heart. Thank you so much. The quality of a leader is measured by the development of the institution he or she is heading. that too within a short span of time. That's what Professor Dr. Naresh Vatsar has done through this competition. Just 4 months of him taking charge of the School of Law. And you can see what's the development. Srimati SHAKUNTALA Devi Memorial National Moot Court Competition for the first time in our School of Law. And this name is going to definitely find a place among the prominent moot court competitions in India for sure. Thank you so much. And if you consider this competition and program as a winning one, then the major reason is Dr. Renuma. She was monitoring everything from A to Z to make this a successful event. Ma'am, thank you so much for all your guidance, all your support, and we have truly no words to thank you. Thank you so much, ma'am. And the other one in this line is the Moot Court Society member faculties. Dr. Syed Ali, the coordinator, Professor Shashank, the co-coordinator, Dr. Aradhika, Professor Shreya, Professor Rajat. They are working for make this competition as a successful one from the last 2 months. And you can see the result here today. And I don't know, it is very formal to thank them, but still, thanks a lot to all of you. Thank you so much. And the participants. And we all may be feeling a vacuum, particularly myself. I have an emotional vacuum here. One person is not present here because she is on a kind of travel after her wedding. Who is the backbone of School of Law? I don't have words to thank her, in fact. Truly speaking, even though she is not available, she was giving all the necessary instructions to all what to be done. So this is a successful event just because of all of the commitment and unwavering support. Thanks a lot for Advocate Aradhana Madam from my heart. Thank you so much. And then for all participant students, we thank all of you with our wholehearted mind itself. Thank you so much for making this first Srimati SHAKUNTALA Devi National Moot Court Competition as a successful event for School of Law. And I would like to thank the partners of this program, SEC Online and Scribor also, for their invaluable contribution for this competition. Thank you so much. And the next one are the special thanks deserving people, the volunteer students who volunteered their entire time and energy for making this competition the most successful one. And I already told during the inaugural time, hats off to you again and again, my volunteer students. Love you all. And all my dear colleagues and all my other dear students, thank you so much for being here with your presence and participation and for each simple contribution you made. I hope I covered everybody, but I cannot finish without thanking our anchors, Professor Prowess and Professor Priya. Both of them, you do not know how we were struggling them to make the anchoring ready for it. Thank you so much to all of you. We will meet again. Let this competition be a rewarding event for all of us. Let us have the national anthem and let us wind up after the national anthem. Thank you so much.
Dear student, please make silence. Thank you.
You will have the national anthem, and then I request, in advance, kindly take your seats for 1 more minute before, so that our guests may leave, and then we may proceed. We will now begin the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा